Good morning. It's April 10th, and this is To My Liberal Friends. Well, Democrats have been waging a battle against Donald Trump via the courtroom for years. Now he's back in the White House, along with majorities in both the House and Senate. They've been attacking his decisions in the courts and finding sympathetic judges to issue injunctions against actions by the administration. I think anyone watching this scenario play out realizes that those filing these lawsuits have been forum shopping, and most of the decisions have been made by judges appointed by Democratic presidents. I'll freely admit the Republicans would probably be doing something similar if the roles were reversed. But that number of lawsuits has become so large that the Supreme Court had to step in and take some form of action. We've been watching federal district court judges issue rulings that they claim apply nationwide. Many legal experts have expressed concern about this pattern, believing they are outside of their jurisdiction. And I've been saying since this pattern started that eventually the Supreme Court would have to step in and rule on the powers of the presidency under Article 2 of the Constitution. In the last week, I think we might be seeing the end of this forum shopping as higher courts are finally stepping in. One thing can be assured of is that judges do not like to be overturned on appeal. It says they got the law wrong. Because district judges aspire to the appellate level, and those in appellate courts have their eye on the Supreme Court. This week's spate of Supreme Court rulings matter on the merits, but matter more on the message. The justices are finally weighing in on the swirl of litigation and injunctions that have met this Donald Trump administration and appear intent on imposing some form of order. Technical details of the rulings aside, the justices are reminding Trump-hostile lawyers and lower court judges that they have a duty to follow the rules on venues, cause of action, jurisdiction, and standing, and to exercise a little judicial modesty. And as I said, anti-Trump litigants are full-throated in forum shopping, using whatever excuse to file cases in circuits with greater numbers of liberal judges. The Supreme Court on Monday, in an unsigned opinion, rebuked this practice, lifting D.C. Court Judge James Boasberg's block on Trump's deportation of Venezuelans under the Alien Enemies Act. The High Court noted that the correct way to protest the use of this law was with habeas petitions in the venue where the detainees are confined. In this case, Texas, not the Beltway, not Washington, D.C. Justice Brett Kavanaugh, in a concurrence to that ruling, further explained that Judge Boasberg erred in even entertaining the plaintiff's claims the administration had violated the Administrative Procedures Act with the deportations. He reminded them only to what history and precedent show that habeas governs transfer claims, but the statute makes clear that the claims under the APA are not available where there's another adequate remedy in a court. Ouch. Judge Boasberg and his clerks must be hanging their heads on those comments. The High Court last Friday sent a similar reminder about courts' authority to hear cases. In a per curiam, it slapped down Massachusetts District Judge Myong Yoon ordered that the administration must continue paying out Education Department teachers training grants. 8 Democratic states sued in Boston, where Judge Yoon found the administration had violated the Administrative Procedures Act and ordered it to pay up. Supreme Court instead ruled that, quote, government is likely to succeed in showing the district court lacked jurisdiction, end quote. And that's in the first place, and the suit belongs in the Court of Federal Claims. In a Tuesday order, the Supreme Court stayed California District Judge William Alsup's directive that the administration must reinstate some 16,000 fired federal probationary workers, noting the plaintiffs had no standing to bring the case in the first place. Quote, the district court's injunction was based solely on allegations of the 9 nonprofit organization plaintiffs in this case. But under established law, those allegations are presently insufficient to support the organization's standing, end quote. In other words, those organizations had not been harmed, and the individuals who had been fired would have to file their own cases. Supreme Court made it very clear with some not so subtle criticism of the rashness and overreach of many of these district judges. It was a clear signal to dozens of these judges that they lacked the power to issue these sweeping nationwide orders. Now, before we get too deep into politics, I would point out that these decisions were not partisan, but rather based on procedure. They primarily served to allow the administration space to make its case in court. The High Court's only substantial ruling in the deportation case was a requirement that the administration won't appreciate, in order that the government henceforth provide notice and opportunity for judicial review of any potential deportees under the Alien Enemies Act. On the political side, the House passed a bill introduced by Darrell Issa, the No Rogue Ruling Act, on a partisan vote that limit district courts' power and force them to focus their scope on the parties affected. Now, I believe that's more than likely to be killed by a filibuster in the Senate, but I would point out that the Solicitor General under Joe Biden complained about district court judges abusing their powers. When it favored Democrats, they cheered these judges on. But when it went against them, they wanted some control on those judges. All in all, these decisions should bring some clarity to the legal efforts of those challenging the administration in court. It will give these district judges real pause in how they're handling cases in these areas. This has been To My Liberal Friends. Thanks for listening.